Good evening, everyone. My name is Bob Boyle, and it was my privilege to represent Richard Williams at the seditious conspiracy trial in Springfield, here in Western Mass, from 1987 when we first came up here till November of 1989 after the verdicts came down. I'm very honored to address you all this evening, but I would like to echo Bill Newman's sentiments that I would gladly have not said anything and would want to be in the audience with you all, and would gladly have deferred to hear Ray Levasseur speak and address from his perspective what happened at that trial. And all of us here, I think, on this panel join in that sentiment, and we would gladly have him speak here to you about what happened in that case, his role, and give a really unique perspective, which unfortunately you're not going to be able to hear tonight. The indictment in this case was returned in July of 1986, and my friend Liz Fink, who I worked with in New York for many, many years, will correct me on these dates because she has one of these photographic memories, and if I'm wrong, she'll tell me that I'm wrong. May of 1986, shortly after a federal trial in Brooklyn, New York, where Liz and I had participated, charging some of the same defendants with some of the same acts that became part of the Massachusetts case. But what was unique here in what became the seditious conspiracy trial was that the defendants were charged, amongst other things, with the crime of seditious conspiracy, which was a law which was rarely used to prosecute individuals here in this country. And it's a law which raised a lot of significant legal issues, political issues, that made the case quite unique. The law in of itself renders it a crime for anyone, and this is the part that's most quoted, to conspire to overthrow the United States government by force and violence. You don't have to do anything, you just have to have that agreement. But there's other subsections of the law which were part of this indictment, and which were also part of the case, in which the government could have proved the charge of seditious conspiracy. For example, it is seditious conspiracy to conspire to prevent or delay the execution of any law of the United States. If you conspire to delay or prevent the execution of any law, tax law, gun rights, you can be charged with seditious conspiracy. And this is also what this case was about. There was also 2 counts which charged the defendants with racketeering and racketeering conspiracy. Now, the racketeering laws, which were passed as part of the Omnibus Crime Control Act in 1970, essentially targeted the mafia. These were statutes which Congress wrote to go after organized crime. So it was also unique in this case, although it was done in a few others before the seditious conspiracy case, that the government used the racketeering laws, which also criminalize association, to charge individuals who were engaged in politically motivated acts, or alleged to have committed politically motivated acts. So these were the 3 charges: seditious conspiracy, conspiracy to commit racketeering, and substantive RICO. In other words, actually participating in a racketeering enterprise. As Liz corrected me, the indictment was returned in May of 1986, at a time after the Brooklyn trial had just completed, and several of the defendants, with the exception of Pat Levasseur, who was not convicted in Brooklyn, receiving substantial prison time. We first came up here, and Liz will probably correct me again with the date. Liz and I sought to be appointed in here in Massachusetts, and that was a long struggle because the courts, it took a year for the defendants to be able to argue to the court to get counsel of their own choosing. There was litigation in the Court of Appeals in Boston, the Federal Court of Appeals, as well as in the lower court. And finally, because the defendants themselves took strong positions in court appearances in Boston that they wanted lawyers of their own choosing, they wanted to be able to present a defense in their own way, they forced the court themselves, acting essentially pro se, representing themselves, to stop an aborted trial in Boston. The case was then moved out here to Springfield, where the courts figured it was one of the only places it could be tried, and out of the Boston area, and they set up a prison facility in Hartford, a special prison facility where Ray, Richard, and the other defendants were kept and be brought back and forth. So I remember in June of 1987, Liz and I were on our way up here. A date was set to start jury selection and trial. And we packed up our cars in Brooklyn, Liz with her dog, and we didn't know when we'd ever come back, where we would be staying, and drove up to Springfield, where the proceedings were going to take place. And the case was assigned to the Honorable William Young, who is a federal judge who normally sits in Boston, but who was designated to hear the case here in Springfield. And I just want to set the scene of what we first saw when the case was on. To bring and at that time there were 8 defendants in the case, back and forth from the federal prison in Hartford to court in Springfield, the police essentially shut down the city of Springfield. The security was so intense, they stopped I-91. They stopped downtown Springfield from cars going in and out for 45 minutes at a time during rush hour in the morning and during rush hour in the evening. Prior to this case, actually, there was not even magnometers in the federal court in Springfield. They were instituted for this case. And so it was big news on the TV each evening. The terrorists coming to Springfield, beware. It was intense, almost like the last week, from what I understand. Showed as much as things change, as much they remain the same. They're animals. They're terrorists. The town is going to be, blown up. They're going to recruit people. Where did I read that? And we were confronted with this situation. How are we going to get a fair trial? And in this atmosphere, very fortunately, we had some local attorneys on our team: Bill Newman, Linda Thompson, who knew the community and who agreed to come onto the case and be court appointed. And a long process, and I'm leaving some things out, of jury selection began. And I think it took us about 8 or 9 months to pick a jury in the case because of the security, because of the publicity, because of the inflammatory and false things in the press. Once again, I think there may have been some of that recently here in the Pioneer Valley. It was extremely difficult to get a jury jurors who did not have preconceived notions of the defendants and the case. Finally, after a long time, we were able to select a jury, and the trial began. Ray Levasseur, by this time, because of some brilliant legal work by Linda Thompson and Dan Myers and others, Barbara Kersey, Jan Lahman and Tom Manning were dismissed from the case. Carol Manning's case was also disposed of. And it went to trial with the three defendants, Ray Levasseur, Pat Levasseur, and my client, Richard Williams, who I represented along with Kenneth King. And the trial began in January 9th, 1989. And a long process began of a learning process for us, learning about the community and how to talk to the community and how to present in a very methodical way and a painstaking way for us, because we made a lot of mistakes, to really show, in spite of all of the vitriol and all of the publicity, to be able to show to this jury from this community that the people on trial were human beings who had histories, whose ideas and indeed even some actions came out of particular historical periods. That they were people. Ray Levasseur, a Vietnam vet. Richard Williams, growing up in the working class in New England. Pat, and I'll let Pat speak for herself. And over this long period of time, with Ray Levasseur representing himself, cross-examining witnesses, doing a brilliant job. Liz Fink, who we gave the trial award to, doing a brilliant job cross-examining and presenting evidence. But mostly it was that give and take every day with people in the courtroom. And I'm sure the jurors will comment on this, that really, I think, changed the tone. That there was nothing here to have this vitriol and fear, so that the jurors could look at the evidence. After all, a trial is about the evidence. It's about whether the government could prove their case. So after an 8-month trial, we finally had summations and deliberations began. And I was mentioning earlier when I was saying hello to Ms. Hubbard, we showed up for the charge to the jury, and the jury was going to be sequestered. And these were jurors from this community, from here in Western Mass. And we walked into court, the lawyers did, and we saw all the jurors with suitcases and trunks. We said, and I said, looked like you were all going away to Europe for like a 9-week vacation. We said, we're going to be here for a while. And we were. It was because for the next, we joked about it. The jury was saying, you all took 9 months to present the evidence. Well, now you're going to wait for us. So for the next 3, I think it was 3.5 weeks. 18 days, once again. So that's only trial days, not including Saturday and Sunday.
And we were sequestered during the week.
And they were all sequestered during this period of time. The jury did their work. They did their work. They looked at the evidence. They reheard testimony. There were enormous documentary exhibits that were admitted. There was debris from some of the explosions. There was everything. The jury took it all and kept us waiting. And each day we came in, and the judge would say hello, and they'd go do their work. And at the end of it, after all of that, actually there was one verdict before the final verdict. The jury returned a verdict of not guilty for everyone on the charge of seditious conspiracy. Verdicts of not guilty. On the charge of racketeering, Pat Levasseur was acquitted on the charge of racketeering. And for the remaining charges, the conspiracy to commit racketeering, and I'm not going to bore you with technical things of law, but conspiracy to commit racketeering is essentially conspiracy to commit conspiracy to associate. The jury could not reach a verdict, refused to convict, did not reach a verdict on those other charges. So after all of this time, after all of the inflammation in the media, the security in downtown Springfield, this is what happened at the end of this trial. A few weeks later, I believe it was in December, late December of 1989 or early January, the government decided to dismiss all of the remaining charges against Pat Lavasser, Richard Williams, and Raymond Lavasser. So once again, after this 2-year period of I don't know how much money, of all of this so-called evidence and what the government tried to portray, it really was an education for me as a relatively young lawyer at the time to know that if you believe in a case, if you present, if to have faith in people, that people can think. Maybe we need to learn a little bit more of that too, that people can think, that people can look critically, that you can win. And that's what happened in this case. It was an enormous victory for everyone. And so that's your general table of contents of what happened, to put this in somewhat of perspective. And there'll be questions later, and now I'm happy to turn it over to my friend, mentor, and colleague, Elizabeth Fink, who I'm sure will fill in a lot of the gaps here that I left out about the case. And thank you all once again for coming, and we'll talk to you soon.